Hi, everybody. Welcome to the Insurance Journal's Academy of Insurance's weekly webinar after show. I'm your host, George, and joining me for the after show today is the director of the Academy of Insurance, Mr. Patrick Raitt, and today's instructor. Today's class was Who is Paying for This? A three-part class on risk transfer, part two. And our instructor, just like in part one, Mr. Casey Roberts. Casey, welcome to the after show. How are you today?
Thanks. I showed up again, George. I appreciate it.
Absolutely. I'm counting my lucky stars. So great to have you. Great to have you back here. And today's class, I felt like was more of a cautionary tale. Lots of like, don't add extra insureds, different things. One of the things you talked about was disclaimers. Can either an insured or an insurer with their risk be the victim of a badly written disclaimer? Like, is that ever a thing that's a sticking point with disputing a claim or trying to get insured for something, like, or a disclaimer is usually written well and we shouldn't worry about it?
Well, the one I stole from an E&O provider, I think is a pretty well written disclaimer. And the reason I utilize it is because it's one to which I have access, and two, one that we like to see, something along those lines. The value of the disclaimer, and I'd love to hear Patrick's thought on this too. The value of a disclaimer is that it's putting people on notice that, look, I've only done certain things for you. I'm not assuming, I don't want you to assume, Mr. Insured, Miss Insured, that I have reviewed the totality of everything. I've only looked at this little portion. That's the only portion I'm going to accept any responsibility for. Now, should there not be coverage and they want coverage, which is when disputes happen, right? And I can't make the dispute go away, but the use of that disclaimer is going to provide me with a certain level of comfort and defense, as in, look, I did what I promised I was going to do. I looked at this section. I complied with this section. They're arguing over here this other section. I didn't look at it because my disclaimer says I didn't, and I don't do that. Patrick?
Yeah, absolutely right there, Casey, because those kinds of disclaimers are helpful for the agency to avoid just such a circumstance. As an underwriter, I wouldn't want to have to review all of the insured's contracts for not just the insurance document, insurance issues, but anything else that may be in there. I would lean heavily on whatever the agent is telling me is required from the insurance requirements, and being aware that an agent's not necessarily an attorney and doesn't necessarily have a background in law, but has seen these contracts, and that's how we end up getting that kind of responsibility, or end up getting that piece of this thing, is that as the expert in insurance for these insureds, the agent can usually pick out from that portion of the contract the information that's necessary to make sure the insured is complying with those requirements, and certainly not over promising anything in those things. No, certainly we wouldn't want an agent to say, yeah, I've reviewed your entire contract and everything is fine. That would be bad.
Casey, I have one more question for you, and that is, you start talking about legal opinions, and then you sort of, and this may be an exciting moment and a rare moment in Academy of Insurance classes, you actually started to kvetch, sort of gesticulate wildly. You actually seem to need some sort of maneuver performed on you, but then you quickly recalibrated and you're all set. Now, what about legal opinions made this happen to you? Were you in some kind of white room where you got really nervous, then all of a sudden you pulled it together in typical Casey Roberts fashion and pressed on, or can you tell us about that?
When you once mentioned a white room, were you speaking of Cream's hit White Room? Because
No,
I read this morning about the writing of the words to White Room, believe it or not. Online.
I believe it. You're a topical guy. No, Murders Only in the Building is a show on Hulu with Steve Martin, Martin Short, and Selena Gomez. And Steve Martin has to perform a song in Martin Short's musical. And every time he starts, he starts to freak out, and then he dreams that he's in a white room, and then when he wakes up, he's caused some sort of damage or made marital promises to people that he otherwise shouldn't have. So I was wondering if you were in some kind of white room, but then quickly, like in 5 seconds, snap back.
Not that I know of. It could have been one of those out of body experiences that I occasionally incur without my knowledge, obviously. And but wherever I was, it was a pretty good place, I'm pretty sure.
Well, I guess legal opinions can induce astral projection in Casey Roberts. So just be careful when you ask him questions about legal wherewithal.
George, in all seriousness, which I know doesn't fit me very well, the beauty of case law, legal opinions, right, is that Patrick teaches classes on insurance coverage. I teach classes on insurance coverage. George, I'm sure with all the stuff you've been doing over the years, you could teach some of these classes as well, okay? And we all believe we know what the policy says and how it should be applied. Then a loss occurs. Litigation ensues. People are hired. Attorneys are hired. Expert witnesses are hired. Everyone opines depending upon their, I know, I love that word, but everyone does. Everyone opines upon their particular area of expertise and their belief. And then the judge, in his or her wisdom, says, okay, I'll listen to you. I've read it all. Here's what it says. Okay. Now, from that day forward, I know now exactly, at least in that state, what those words mean based upon that interpretation. So I refer to a lot of case law and a lot of classes I teach because, quite frankly, it is the one thing that provides clarity to everyone in the insurance industry. Now, we may not like the clarity it provides. We may say, how in the heck you came up with that decision? I got no stinking clue, right? Maybe they had an astral projection or something happening in a white room when they made the decision. I'm not going to say I agree with all the decisions, but when the courts make the decision, the courts have made the decision. Thanks for coming.
Casey, I love it when you say things like opine. And after the after show, I'd like to start a TMAS with you, a Tranche Mutual Admiration Society. And everybody out there, if you don't know what tranche means, look it up. Patrick Raitt, your thoughts on today's class and the topic in general of risk transfer.
Casey is exactly right. It's the case law that ends up being what determines what these policies really say and what they really mean. And that is part of the beauty and curse of working in insurance, because you're dealing with a legal contract. And at the end of the day, if two parties disagree on what that contract means, don't worry. There's a judge somewhere that will tell you what it means. And eventually you may have to swallow whatever it is that the judge says it means, but eventually we get to somebody's opinion on it. Second, I'd like to say, in by way of disclaimer, we neither endorse nor approve of or disapprove of anything related to Hulu, any actors, any shows, or any writers of any shows, or any directors, or any producers, or anything related to anything at all ever, except for what we're doing. And sometimes we don't even approve of that. Having said all of that,
that's a disclaimer.
That's a disclaimer.
The mother of all.
This is really, to me, these kinds of things are what make what we do as insurance professionals really interesting and fun, because we can all have our opinions, and believe me, I've traded emails and conversations with other insurance professionals, other insurance education professionals, and you get 5 or 6 of us in a room, and you may get 5 or 6 different opinions. And sometimes if the conversation goes long enough, you could have double as many opinions, because they start to read and reread, and then they start going off and looking at court cases and looking at state laws and all of that. So it really is fascinating. And I'm going to be honest, I am looking forward to next week's discussion, simply because of one of my favorite little nerdy insurance topics to discuss is the evolution of that CG 2010, just because it's so different today than what it was when it was first published. And that is a case study in, well, we didn't mean for that to happen.
Yeah, just kidding. That's really not what we meant. And it's in George, it will illustrate what we just talked about, as Patrick just said. It's going to say, okay, here's what your language says. Here's what the court says that language meant. And then the insurance companies and ISO are going to say, well, wait, that's not what we meant it to mean. And then the court says, well, then you should change the language because that's what we're going to say it means. And then we get another endorsement with another effective date, and we go through the process again. So it is kind of a fun, it's a trip down memory lane, if you will, okay, for insurance nerds and whack jobs such as myself.
Yes, Patrick.
So I was testifying that I'm on the same boat with him. I don't know if it's the insurance nerd or whack job, but
On that note, I'm going to bring us home. So Casey, thank you so much, and we're looking forward to part 3. Absolutely. So thanks for your help today, and everyone check it out. If at least for the I'm not sure when it was in the class, but when Casey had his attack, and it's one of the more exciting moments in recent Academy class history. So on behalf of our instructor, Casey Roberts, and our director, Patrick Wright, this is your host, George, saying, take care of yourselves, everybody, and we will see you, everybody. And we'll see you next time. Have a great day. Enjoy yourselves.
Thanks, folks.